Okay, so we're going to go into the kind of the next portion of our day today. We've already talked a lot about some of the potential threats, risks, potentially even scared you a little bit on AI for national security, AI for law enforcement, a lot of the different kinds of technology. There's a big obvious question that we addressed a little bit in this panel about regulation. And so we will start to kind of move into that. We've got some very exciting keynote speeches. The first one we will have right now, then we'll have a lunch break, and then we'll move into the next one. But then we're going to have a panel on AI regulation. So right now, it is my honor to introduce Ambassador Thomas Schneider. He is an ambassador of the Swiss government, but more importantly, he is the chair of the Committee on Artificial Intelligence for the Council of Europe. There are a lot of different EU regulatory bodies right now trying to do AI regulation. The Council of Europe is trying to do a big global treaty. I knew Ambassador Schneider when I met him in Strasbourg, France, over 2 years ago, and he impressed me so much with his ability to really wield the technical issues that were coming up from civil society, from different governments, from a lot of the subject matter experts that we had in the room, as well as a depth for diplomatic negotiation, for hearing every voice that was there, and for being able to understand a lot of the very inherent controversial conflict in between these different people. So it's my pleasure to welcome here today, and I'm really excited to hear his remarks.
Thank you, Natalie, for this very kind introduction. My name is Thomas. I'm from Switzerland, which is a small country in the middle of Europe. I'm not sure whether there are CLE credits for this session, but you will have to ask the people that know about this. It's funny, when I went to university, we basically just needed to show up every now and then. We had six hours of compulsory lessons a week, and the rest was free for all kinds of other activities that were not necessarily linked to university, but I realized that bureaucracy has also made its way into education systems. So, as I said, I'm very honored to be here with you. I'm not a specialist in national security. I come from a media, telecom, internet governance area, dealing with human rights, dealing with market regulations, and so on. So that you know, and I'm a historian and economist. I'm also not a lawyer. Maybe that will explain a few things that I say. It was quite good to see also that the last panel actually made a smooth transition to what I'm going to talk about. And when we talk about AI and also data, this sometimes reminds me about the discussions of what was going on about 200 years or 150 years ago when engines made their ways into daily lives. Because in my view, there's a few analogies between engines and AI. Engines were either put in machines to process goods, nutrition, whatever, or they put in machines that were moving from A to B, moving people or moving other things from A to B. Like now we have AI systems that are, for the time being, at least basically a further development of analytical statistics that prepare or take decisions, calculate probabilities on the one hand, or they process or generate content. Both of them replace human labor. The machines used to replace physical labor. Now we are replacing cognitive labor. And there are some parallels with this that I will refer to later. I think also when we talk about AI and its potential, but also its risks or its transformation potential, we have to talk about platformization, because platformization is based on the use of data with or the processing of data with algorithms, which is transforming all our aspects of our societies and economies, and is basically unstoppable because just economically it's so much more efficient to use platforms to bring personalized needs and personalized offers together, and that of course has an effect. I don't think that we have to go too much into the opportunities and risks that AI systems bring about. I guess you all know them. But of course, just to focus on a few of them, again, the transformation of our economies, the transformation of labor raises hopes, raises fears, depending on which side you think you will be in the next few years. Some people are afraid of scaling effects, that these will produce new gatekeepers that will control not just maybe their own market segment, but may become gatekeepers for many aspects or all aspects of our societies. Big tech in Europe is seen by some people at least as a threat because it's perceived as an oligopoly of a fairly small number of companies that have a growing influence over our lives, not just the economies. And then, of course, talking about misinformation, disinformation, this is not a new thing. If you look at how the Russians were able to fake or manipulate pictures 100 years ago, this is fascinating. But of course, now you can do it on a much larger scale. And you actually with less skills that you need to have yourself. And of course, we need to find a way to educate our societies and maybe introduce rules on how to deal with misinformation and disinformation to keep our societies, our democracies functioning. This is in particular important also for my country. We do have a system of fairly advanced direct democratic means where in the end, the people themselves vote on bills, on laws, on changes in the constitution. And of course, you want to have educated and well-informed citizens that are able to take these decisions. And then, of course, every new technology creates winners and losers. This is also not new to AI. And if we talk about secure, robust, and trustworthy AI, if we want to take our citizens, our industry players along on this journey, if we want to build trust, we need to find answers for those that are afraid they would be losing out, to give them a perspective. Otherwise, and this is also a parallel that you see with engines in Switzerland in the 19th century. Some textile workers that used to work at home in small groups, they burned a textile factory in 1832 because the government decided not to ban the emergence of factories that were slightly more efficient than they themselves. At the same time, you had people that were ignoring the potential of engines, like the last German Kaiser, Wilhelm II. He said in the early 20th century, "I bet on the horse, the automobile has no future." Well, we still have horses, but we also do have some other new means. And another example, like banning the use of technology is not always very efficient. In the canton of Graubünden, this is the Swiss nice mountain areas with places like St. Moritz and Davos. In 1900, the government decided to ban cars from its whole territory for 25 years. And then there was a public referendum actually in 1925 that then allowed cars. So the reactions to transformations are not necessarily new either. But of course, there are new elements to AI that you cannot compare to what we have with the engines. But the key question is, how can we use these tools for innovation, for economic innovation, for societal innovation, and how can we minimize risks and impacts that we do not want to see? And there are some challenges. Normally, if you work for a government or for a regulator, the answer is you regulate. Now, we prefer to talk more and more about governance instead of regulation because there is a difference. It implies also more like multi-stakeholder or distributed governance models, which are something that I'm still trying to explain to some people in my own country that are not yet that familiar with this concept, that this may be the future. But the question is, for instance, what are we talking about? What is AI? What is not AI? Last year at the EuroDIC conference in Italy, there was an Italian guy that said, well, the EU with their AI Act, this is all fine. But if I declare that what my tool is doing is not AI, it's just advanced analytical statistics, so the whole thing will not apply to me, so I'm fine. So the definition, of course, is a challenge with something that is evolving as fast. We are supposed to find a definition for this convention that should hold for decades. How do you do that when you don't even know what comes up tomorrow? So how do you regulate or govern something that is extremely context dependent? The same algorithm may have completely different effects, even if you use it in the same sector like health. If one algorithm is suggesting a next step in a heart surgery situation, or the same algorithm is just advising people that have a cough or something, of course, how do you do this graduated and differentiated approach? And another issue, of course, is the globalization of these technologies, whereas an engine at the time it was built was standing in a particular place, needed oil that was coming from a particular place. With the dematerialization of data, of software, of course, the international component of this is much more important than it used to be. And then, of course, the question is also, how much can you do or should you do with soft law instruments, with or self-regulatory models? Where do you need, and then how do you do it? Where do you need binding instruments? And one key question that also was raised is, what is actually new? Where are the gaps? We do have an existing legal system that was able to be developed alongside technical innovation already before. So to what extent, and this is something that is very intensely discussed in Switzerland, because we have a tendency to not want laws, not want new laws unless it's really necessary. So what are the problems that we cannot solve with existing legislation or existing regulation, or with just amending those like we had before? What is the new element that needs really fundamentally new regulation? And this is an open question. If we take the engines again, we do not have one engine law today in our countries. We have hundreds or thousands, probably rather, of technical, legal, and socio-cultural standards that are dealing with the use of engine in particular context. And some of them are fairly harmonized. If you take the aviation, of course, it makes sense to have the same rules no matter on which airport you try to land a plane in the world. If you take cars, the Germans are still fine with the idea of having no speed limits on some of their motorways, whereas in other countries, also this one, it's quite clearly regulated. And it is not necessarily so that, for instance, Germany doesn't have a higher accident rate than Italy or Portugal or other countries in Europe that, at least on paper, have much stricter laws about traffic. So which is the right tool to address the right problem or achieve a particular political or social cultural goal also depends on the culture of a country, on the risk, the way how a culture deals with risks, whether people want to be protected by the state or people rather tend to want to protect themselves and not be told by the state how they do it. So these are differences that we have in the engine sector, in the regulation of engines, and we'll also somehow have to have it when dealing with AI, but on a different level because it's a more global instrument. So where are we today with AI governance if you take it from an international point of view? The OECD, Council of Europe, UNESCO, and other intergovernmental international bodies have developed soft law standards since 2018. It started in Europe. In my field, it started with Cambridge Analytica and the questions about what does this mean for democracy, for public opinion shaping. The Council of Europe started to develop soft law. The Council of Europe in 2019 developed an ethical charter for the use of AI in judicial systems, which is also a soft law instrument. The OECD guidelines is probably the worldwide most known, whose definition has now just been revised after 4 years. And UNESCO, which is the most global instrument, this recommendation on ethics of AI that date from 2 years back. We have lots of industry self-regulatory guidelines that companies give themselves, or industry associations give themselves. We have lots of guidance from think tanks and networks and NGOs. And the question is this enough, or where and if, how do we need binding tools that maybe complement these things? And at the Council of Europe, by the way, I'm not sure how familiar you are with European institutions. The Council of Europe has got nothing to do with the European Union. Just to make that clear, the Council of Europe is like the UN for Europe that was created after the Second World War, inspired by people like Winston Churchill in the end of the 40s, and has 3 mandates to promote and secure human rights, democracy, and rule of law. It has more than 250 conventions. The most famous, of course, the Convention on Human Rights. And it has a number of conventions like the Cybercrime Convention or the Convention 108 on automated data processing that are not only meant to be signed by the members of the Council of Europe, the 46 European states, but also can also be signed by non-members. And the Cybercrime Convention, for instance, is one where the US, Canada, and a number of other countries are member. They also have been member in the elaboration. We'll get to that. So the EU decided that it may be useful to have something binding for their internal market, like the EU Digital Single Market, what it used to be called, for a market regulation with market regulation objectives. And the Council of Europe it was decided that we would need a tool that should not necessarily create new rights, but would would give guidance in a binding way on a principle level how to exercise or how to hold up the values of human rights, democracy, and rule of law when using AI. So the AI Act of the European Union is also following the institutional logic that the European Commission only has a mandate for regulating markets, not for dealing with national security or human rights. So they took it from there. They have developed now a law that is about to be finalized. They are in the so-called final stages of the trilogue between the Parliament of the European Union, the Council of the Member States, and the Commission. The final, maybe final trilogue is supposed to take place early December. And what they developed is a market regulatory tool that is based on their idea of, from the traditional world, basically, you may know the CE sign that is on many products, that you control something, it's tested according to some principles, and then you let it go to the market. And now they're trying to develop this into something that is more agile, more life cycle oriented, and give some guidance on product safety, but also on infringement of human rights and maybe dangers to democracy, based on what they call the risk-based approach. I would call it graduated and differentiated approach. They don't want to over-regulate. They don't want to regulate things that have no negative impacts. But then the question is, how do you actually operationalize such a risk assessment or impact assessment into something legally sound, technically feasible? And this is actually, apart from the text of the law, this is the exciting part, how to operationalize no matter what system you have. The US, according to the executive order, is trying to go, let's say, to do something similar with different means, also because the institutional setting and the political situation is different. In the end, also there, we will see to what extent voluntary commitments are enough, to what extent technical standards can serve a purpose, what may be gaps that the society would want to fill. What is clear to most of us is that because this is taking place in a globalized digital world, it would be good to have some shared principles across the globe, at least from a Council of Europe perspective, at least on for those countries that uphold the values of human rights, democracy, and rule of law. And this is what this convention is trying to do. It's not trying to create new rights. It's trying to establish some principles that should be upheld when using AI in order to secure existing values and existing rights. And also, this is set up as a process that is not only for the European member states, but for other countries for the time being, and the number keeps growing. We have, let me read it, Argentina, Canada, Costa Rica, Israel, Japan, Mexico, Peru, Uruguay, and the United States participating. They are formally observers, but because we want this convention to be attractive and accepted and signed and ratified, of course, de facto, you treat everybody as equal, whether you're formally a member of the institution or an observer. So the goal here is, again, not to create new rights, but to give guidance on how to use these technologies, how to live up to some principles so that our traditional values that we've established after the big killings of the two world wars in the last century, that we can keep this up and find ways to deal with new technology in a way that it doesn't damage or infringe with these rights. To tell you in a minute what is in this convention, there's a few general obligations about protecting, respecting human rights, protecting democratic processes, their functioning, protecting rule of law. And then we have high-level principles like human dignity, individual autonomy, transparency and oversight, accountability and responsibility, equality and non-discrimination, privacy, personal data, preservation of health and the environment, reliability and trust, and safe innovation. And then there's some provision about the fact that you need to have a risk and impact assessment in your society in order to find the appropriate response to risks and impacts. But we don't want to tell a government or a state how to do this, as long as it's living up to some basic components that this should have. Also, we do not intend, or the convention does not intend, to tell a government how legally it should govern AI, whether through laws, how exactly it should do it with the private sector. If voluntary commitments are fine, if they are serving their purpose, then this is fine. you just need to do whatever you can as a state to make sure that democracy, rule of law, and human rights are respected. And we hope that we'll have this convention finalize the draft by next March, which is fairly ambitious because we do have some challenges, and this is what I will end with. First of all, is the application. In Europe, as states, we are bound by the European Convention on Human Rights. That makes us having not just negative obligations on things that we are not allowed to do as states, but we have to do things to make sure that people's rights are protected. And that includes also working on private sector, that private actors respect people's rights. And if somebody is not content, he can go to national courts and then to the human rights courts in Strasbourg. And if the court in Strasbourg thinks that the laws or the regulation is not living up to the requirements of protecting people's rights, they can tell a state to maybe reform its regulation. And this is something that non-Council of Europe member states simply don't have. So we have to find a way to respect their differences in how and to what level you can actually enforce human rights, even how you define it, but nevertheless focus on the commonalities of that our people have rights, that we care about democracy and rule of law. And this is a challenge on how we formulate this in a way that it's not, in a country like the US, there's not a fear that the government or the state would be forced to do something that it cannot or it would not want for geopolitical or economic or other reasons. At the same time, in Europe, if you would only limit the convention to state actors, people expect their rights to be protected, whether it's by the state or by private actors. And in history, you have cases, all of us have cases in Europe where our rights were infringed by the state, but also where our rights were infringed by private actors. So we somehow need to cover both. The question is how. And then this is also, of course, something that I'm eager to hear your views on how to deal with national security. I must say that the Council of Europe does not have a mandate. It was set up as having no mandate for military or defense issues. That's simply not in the remit of the Council of Europe. But it has a mandate that covers all civilian issues, and then includes law enforcement, includes fight against terrorism. There's a convention about how to fight against terrorists in a human rights compatible way, and so on and so forth. So that's the approach of the Council of Europe. But how we also there, we are aware that, for instance, when it comes to the principle of transparency, you may not be forced to tell a criminal in advance that you will come and go after him. So there may be a need for exemptions of some provisions in order to allow national people working in the field of national security to do their job. And also there the question is, how do we formulate it? Because at the same time, if you want to have people in the industry trust AI, if national security is not somehow operating in a clear legal framework, people may not want to give their data and share their data, and they simply will not use the potential of AI because it's not clear. So there's an interest, I think, on both sides to allow national security people to do their job, but at the same time to do it in some limits that people know, okay, this is what can happen to me, and this is what should not happen to me. And the last sentence is, whether we have voluntary commitments or a horizontal law like the EU or the Japanese that try to go for sectoral developments, I think we have to think, and you as lawyers, we have to think about how do we develop our rule-making systems so that they become as agile, as dynamic as the technologies they are supposed to cope with. Because if we spend 5 years on working on a law and then it goes to parliament or whatever, or in my case, there's a public referendum and people say no because they don't like something, that it will take us another 5 years. And if you take 10 years for a law, then you're desperately behind the reality. So we need to find new ways of working on constantly evolving legal bases with beta versions or whatever you call it. And I think this is something that we should keep in our minds, that we need a fundamental change in how we regulate or govern our societies, because the tools of the 19th century may not necessarily be appropriate for the 21st. Thank you.